My name is Cynthia Krus, and I'm the executive partner at Eversheds Sutherland. And I'm joined today by Beyea, a partner with the firm, and Payam, Siadatpour, I have to say that all the time, and as a counsel. We're going to talk today in our first Lunch and Learn series about interval funds and closed-end funds. And so we're going to talk through some of the mechanics, how you do the distribution, whether you need multi-share class relief, and any distribution matters. We've got a presentation for you today, and we're going to walk through that. And if you want copies of that, you can contact myself, Cindy, or Payam after our webinar. Anyway, and if you have any questions during the presentation, you can go down to the text box and type those in, and we'll try and address your questions as we're going through the slide deck and the webinar. So today we're going to be talking about the closed-end funds to begin with, and closed-end funds start off for the most part as listed funds. However, in the past couple of years, we've seen a lot more focus on what I would consider non-traditional closed-end funds, which are the non-traded, which were an outgrowth of the non-traded REITs and non-traded BDCs. As a result of the market conditions, market demand, regulatory requirements, there's been a renewed interest in the non-traded closed-end funds and now interval funds. And so that's why we're addressing that today. So I'm going to walk through a couple questions on regulatory frameworks and that type of thing, and we're going to have Cindy focus on the closed-end fund piece and then move to interval funds, and Payam's going to lead us through that. So Cindy, can you give us some of the kind of description of the regulatory framework that closed-end funds, especially the non-traded, operate in?
Sure. And as you mentioned, we're focusing here mostly on the non-traded closed-end funds as sort of a means of comparing them to interval funds. However, the general regulatory framework that applies to non-traded closed-end funds, for a lot of it also applies to listed closed-end funds. So a closed-end fund, as defined under the Investment Company Act of 1940, is defined by the absence of not being an open-end fund. So the defining characteristic of a closed-end fund is simply just that it does not issue redeemable securities. As a registered investment company, a closed-end fund is exempt from substantive state regulation, which is an important fact. The state may not comment on your registration statement. A closed-end fund still does need to file notice filings, but they're not. They can't be provided. They don't get comments from the states. In terms of the registration statement that a non-traded fund would offer its securities under, Rule 415 only allows the same registration statement to be used for a period of 3 years, and this is something that we'll contrast later with how interval funds operate. And of course, that during that 3-year period, financial statements need to be kept up to date, and that can be done via a post-effective amendment filed under Form POS 8C, which is subject to substantive SEC review. And generally, as a matter of practice, it must be declared effective by the SEC.
So the issue is that an open-end fund has an unlimited number of securities that they can offer and redeem, and a closed-end has a specific number. And so to some extent, it's almost you've got some comparison between the non-traded closed-end is somewhat similar or more alike on an open-end fund, even though you're using the closed-end fund regulatory framework.
For an interval fund, right? The ability, as we'll discuss later, the ability to continue your registration statement without filing a new N2 is something very akin to what an open-end fund does. And then just in terms of, we know a number of our audience members are very familiar with business development companies or BDCs, and so to contrast the closed-end fund to the BDC space, it's a different form. There are different forms that are filed. There's no 8Ks filed for a closed-end fund. The only real way to update information would be to file a prospectus supplement under 497, which is often referred to as a sticker. So you sticker in your prospectus.
An old term when you use paper.
Right. And then I guess turning to the next slide, just additional information about the regulatory framework. And again, contrasting these points with the BDC. So there are a closed-end fund is subject to more stringent leverage limitations, 300%. It is also not as able to charge an incentive fee. BDCs have a specific exemption to permit them to charge an incentive fee on capital gains, and closed-end funds do not have that. There is also no ability to have blanket annual approval to sell shares below NAV.
So they would have to do it on an individual transaction-by-transaction basis.
Correct.
So what are the reporting requirements? You mentioned the 8K, but what else do they have to file?
Sure. So in the next couple of slides, we have mentioned the new form requirements that will come. We've included the compliance date on the slides, and just as a bit of background, these may change. In August, or 2 months ago now, the ICI formally requested that the SEC delay the effectiveness date of these new form requirements, in no small part due to the revelations that the SEC has itself, the EDGAR system, had been hacked. So I guess this is a bit of a stay tuned as to what will come. But a little bit of background on the current form requirements before we discuss the new forms. The currently closed-end funds prepare annual and semi-annual reports that are sent to shareholders, and those are then filed with the SEC on Form NCSR. And in quarters when they don't file the NCSR, they file information about portfolio holdings on a Form NQ. And then 2 times per year, closed-end funds have to file this Form NSAR, which is sort of sensitive information. There's a lot of yes or no questions, a lot of fill in the blanks with numbers. And so the NQ and then the NSAR are the forms that are slotted to go away with the adoption of these new forms. So NPORT is a form that will replace NQ, but it is a monthly form that will be filed at the 30 days after the end of each month. And it is not going to be made public on a monthly basis, but only on a quarterly basis. And this is sort of wherein a lot of the concern about the SEC's own cybersecurity lies, because a lot of this information is confidential and is meant to be kept confidential, and issuers don't want to be giving it to the SEC if the SEC can't protect it. And then the other new form is the NSEN, which will replace the NSAR, and will only be filed annually versus semi-annually, and it will have different information than what the NSAR, but it's also generally a sort of a census type information, providing the SEC with information about what the fund is doing and how it operates.
So really, the SEC here is taking advantage of the speed of the digital technology as a result of requiring it on a monthly basis. A couple of years ago, you would have never thought that a fund could actually produce information that quickly. So they're going to have the information for a while. It seems like to me that this is eventually going to be something that might be available more even on a monthly basis as opposed to quarterly, and the SEC seems like it's testing it out a bit. But it's going to be a pretty fast pace on which information is going to be known. And
that's certainly one of the concerns of funds, that getting up to speed and being able to compile all this information and put it in the form and submit it to the SEC on time. And that's one main concern. And then also the concern of keeping confidential what information really needs to be kept confidential to protect the investors of the fund.
But consistent with now the T+2, right, as opposed to the T+3, if that just was implemented, the SEC is definitely trying to take advantage of the availability of information. So what are the compliance requirements for a closed-end fund?
Sure. In general, Rule 38A1 applies. So just like any investment company that's regulated by the SEC, a closed-end fund has to have a robust compliance program and have a CCO. There are also general regulations, to protect investors, that assets have to be held in custody pursuant to specific rules under the SEC. And then, in addition, to protect the assets of the fund, a closed-end fund has to have a fidelity bond. And these are rules that apply to all investment companies.
Right. So this is standard across whether you're talking about a mutual fund,
sure,
a listed closed-end fund, or non-traded. And we'll talk about the interval in a minute, but if you're going to be registered with the SEC or are basically offering public securities, you're likely going to have to reach the same type of compliance.
Correct. Right. And then just a little information about the board. It's the same. This is, again, the requirements for the board of a closed-end fund are really no different than any regulated investment company. The 40 Act itself only requires 40% independence, but there are a number of provisions and rules under the Act that require you to have a majority to be independent. A number of exemptive rules. There are some listed here on this slide. Perhaps one of the most common ones is the joint fidelity bond. Right, a number of funds take advantage of that, and if you rely on the rule to have a joint fidelity bond, you have to have a majority independent.
And just before we started, we were talking, we can't think of any funds that we're aware of that don't use a majority of the board. Right. So spending some time on the, basically getting your board together and your independence requirements when you first have someone join a board, but also as you go through it, definitely they're the gatekeepers as far as the SEC is concerned, and they're the first line of defense when you're talking about compliance.
Right, and I think you wouldn't want to be in a position to have to explain to the SEC why you didn't have a majority, even if you're not technically required. And so
closed-end funds, the tax.
Closed-end funds, again, like they can elect, pass-through taxation, which is obviously a beneficial tax structure, and one of the reasons that people are interested in investment companies.
We'll see where we end up on all that with tax legislation. So one of the main areas is shareholder liquidity, especially if we're talking about the non-traded world. What are the repurchase requirements for a closed-end fund?
Sure. For obviously a listed closed-end fund doesn't have to address these issues because they offer liquidity just by being listed. But a non-traded closed-end fund actually doesn't have any requirements, technically about when it would offer to repurchase shares or how it does offer liquidity. That being said, a model has developed that because obviously shareholders don't necessarily want to get into a fund if there's no opportunity for liquidity. And so a model has developed that on its face actually looks a lot like the way interval funds operate, which is interesting. But because they're not operating under the interval fund rules, they're subject to different regulations. And so historically, most non-traded closed-end funds have offered to repurchase their shares quarterly. This is solely pursuant to board action. The board can, there's no required amount that needs to be repurchased. There's no required frequency of these repurchases, and the board can terminate it at any time. And this is done, pursuant to a standard tender offer.
Right, a standard tender offer means the tender offer forms, so you're filing with the SEC, keeping it open for the particular number of days, 20 days. So it's a pretty standardized process, but it's fairly intensive.
It's a lengthy document that must be filed, correct.
So all the information you hear about the repurchase programs is really a market-driven issue, meaning if you're going to do the same size repurchase as you do your DRIP, all of that type of thing is really dictated by kind of where the underwriters have or the market has shifted.
The selling firms, who will sell your product based on what you're offering.
Correct. So looking at the most recent versions of whatever is at the SEC or whatever is being approved is one of the ways of making sure you've got the standard process and numbers and amounts for the repurchase program. So what are some of the other issues around underwriting and compensation for a closed-end fund?
Sure, and this is one area where it's a very big distinction between a standard non-traded closed-end fund and an interval fund. A standard non-traded closed-end fund is subject to substantive FINRA review, meaning you must file your registration statement with FINRA, and they can provide comments, and you also need to request a no objection letter before commencing sales. And so this obviously adds additional cost and time to the offering. So it's definitely, this process is viewed as a negative. The FINRA regulates non-traded closed-end funds under Rule 5110, and while there is no, as you know, there is no explicit cap on underwriting comp, FINRA has generally said that 8% is it, and they have. And that contrasts with, with the non-traded BDCs and REITs, which are at 10%. So this is a lower a lower cap, and also FINRA has taken the position that due diligence expenses need to be included in that cap too. So
and this is obviously a retail product,
right.
And so as a result, the FINRA process is fairly extensive, especially when you're talking about not only the FINRA, your prospectus, but also your advertising needs to go through as a FINRA review process. So it's very similar to the SEC process, meaning in length of time, if not a little bit longer, when you're talking about these types of products.
Sure, it can be, especially if you're trying to do something different that they haven't, right, if you have something they haven't seen before. So it definitely can add time and expense to the process.
Right. And with the changes as a result of the new DOL rules and things like that, there's been some movement around compensation, and so there's been a variety of things that have been going through FINRA that, and as you said, they take a little bit longer, but they certainly you'll spend time on it is really the point where, and sometimes
sure.
when you're going through just an underwritten offering, you wouldn't see that.
Right.
So now we're going to shift over to interval funds and try and compare and contrast a little bit. So we're going to, Payam's going to join us for that discussion, and both myself and Cindy will be asking him questions just to give him a little bit of a hard time. And the reason we decided to talk about interval funds is because we have seen quite a bit of activity recently. There's currently 56 active interval funds with about $3.9 billion in assets. And I would bet that has actually been raised in the last 2 or 3 years because you really couldn't find very many active interval funds prior to that. The interval funds, the composition of the portfolio or the investment strategies is fairly broad. It's real estate, middle market loans, which is newer to the structure, and then also you have listed and non-listed investments. So when you break it down, you can see at the bottom of the slide the various areas. Most of it is still in real estate, but I do think that as you see more managers who have done debt or credit, you may see more that look a little bit like the BDCs in some situations. So Payam, can you maybe walk us through what the requirements for an interval fund, which I bet before today a lot of people hadn't heard much about?
Sure. So the interval fund is a registered closed-end fund. So a lot of the requirements, if not most of the requirements that Cindy alluded to, will also apply to an interval fund. So the limitations on leverage, the limitations on the types of incentive fees that an advisor can charge, the ability to sell below NAV, all those would apply equally to an interval fund. Likewise, with the forms that Cindy alluded to, the same process, including the new forms, will all apply to interval funds. But where interval funds are different is that they're governed specifically by Rule 23C3, which an interval fund effectively has to comply with in order to get the benefits that we'll discuss in these slides.
Great. So effectively, because they're a subset of a closed-end fund, similar to a BDC, the same type of rules that we were just talking about really do kind of cross over. It's a covered security, the registration requirements or the effectiveness that we talked about, as well as the FINRA review, really do apply here with some tweaks, which we'll go through.
Right. And the rules relating to the public offerings of interval funds is really where we start to see some significant differences between the traditional closed-end funds that Cindy discussed and interval funds. So, like Cynthia just mentioned, they're still not subject to state review, just as traditional non-traded BDCs are. But I'm sorry, non-traded closed-end funds. But one big distinction, Cindy referred to the limitation of 3 years for a traditional closed-end fund's registration statement. Interval funds do not have that limitation. So an interval fund can file its registration statement, and assuming certain conditions are satisfied, that registration statement can be used effectively for the life of the interval fund offering, regardless of how long it goes. As it relates to the post-effective amendment process, like Cindy mentioned, when you have a registration statement, you do have to update it with financials or other material events that occur. With the traditional non-traded closed-end funds, when you file a post-effective amendment, that post-effective amendment is subject to SEC review. In the case of an interval fund, if you're updating the registration statement, for example, to update the financial statements, that registration statement is effective immediately upon filing without any SEC review. Now, there are some types of post-effective amendments that are more material, but even in those cases, you have an automatic effectiveness such that you file the registration statement, the SEC can review it, but you will be declared effective within 60 days. So you have a lot more predictability in terms of the effectiveness of your registration statement. And finally, and Cindy referred to this as well, maybe most significantly as it relates to FINRA, interval funds do not have to file their registration statements or otherwise have their offering terms and compensation terms to brokers cleared by FINRA. So as soon as you're declared effective by the SEC, you do not need to get FINRA clearance. You can just simply start selling your shares as an interval fund.
So really this kind of eliminates some of the issues that we saw a couple of years ago with some of the non-traded BDCs, where there were some issues that arose with the N2s, and people were having to grapple with whether they were going to have to stop selling or how they sell through that, and then get effective. If you've got automatic effectiveness, you have more certainty around that. Certainly, the SEC could still ask you to maybe potentially withdraw and refile or something if there was a big issue, but you definitely have a lot more certainty around these registration statements than we've seen in the past in some of the BDC structures.
Right, especially if you have nothing material changing and you're just updating your financials as all funds have to do, then you're just effective immediately.
Right. So one of the areas I think that people would want to focus on is the how do you determine the price? So we don't have a market. We're not listed. Most interval funds, they're required to be priced, or an NAV is determined weekly. Is that the requirement?
That's right. So Rule 23C3 requires an interval fund at a minimum to declare NAV on a weekly basis. Now, if you're offering your shares on a daily basis or continuously, the rule requires that you strike NAV every day. So again, it's a minimum of weekly, and if you're offering, it's daily. And also, as it relates to your repurchase offers as an interval fund, which we'll get into, you also have to declare NAV the 5 business days, every day for the 5 business days before a repurchase request deadline. So in that sense, they're significantly different than a traditional closed-end fund, which, Cindy, correct me if I'm wrong, I guess you really strike NAV is it twice a year when you're filing your annual and semi-annual, unless you're selling.
Well, also if you're repurchasing, that has to be done at NAV too.
Right, but generally it's far less frequent than weekly or even daily. So that's a significant difference.
Right, so, but if we're talking, I mentioned that the portfolios may be just a debt portfolio, somewhat similar to a BDC or other credit funds. How do you do that daily?
Well, that is one of the challenges that interval funds have, but basically what interval funds do is it's not that your board will get together, as say with a BDC, you get your board together quarterly to declare the fair value or declare NAV. Interval funds will adopt policies and procedures related to their valuation that effectively, for lack of a better term, delegates. The board doesn't really delegate the responsibility to strike fair value, but it allows the management of the interval fund, pursuant to the policies and procedures adopted by the board, to strike NAV. This is obviously a lot easier when you have a liquid portfolio if there's a market price, but to the extent you have illiquid assets that require kind of a fair value determination, you just have to make sure your policies and procedures allow for a daily strike of fair value and to be able to take account for any material events that occur on a daily basis.
And in this instance, I think interval funds are learning a lot from mutual funds, because mutual funds have been down this path, whereas most mutual funds do have highly liquid portfolios. They are permitted to have up to 15% in illiquid securities, and even all of those still need to be valued on a daily basis. So most mutual funds have developed very robust policies about how to handle the daily valuation of these less liquid assets, and I think interval funds are taking some cues from them.
Right, but it's something definitely you have to manage for,
yeah.
And build your platform out so that you can handle daily pricing. But I agree, you certainly could look to the other mutual funds or their policies and procedures. It's just a lot more work. If you're going to be doing that. The key is going to
be to make sure that you have not only robust policies and procedures, but that you're actually following them, which obviously the SEC would be very focused on if they were ever to look at your valuation practices.
So I'm going to answer a question that we were just asked because we just passed over that topic, and we're glad to get questions. Is the FINRA precluded from substantive review, or have they just not imposed the requirement for interval funds?
Interval funds are just not governed under 5110. They're governed under Rule 2341, which we'll get to later. So there's no, because it's a completely different structure, right?
More like mutual funds.
It is the mutual fund sales charge rule, correct?
Right. So a mutual fund doesn't go through a pre-approval like what we're talking about as far as reviewing from a substantive standpoint.
Right. You don't file anything with FINRA. I mean, advertising materials are certainly filed with FINRA, but you do not file your offering documents with FINRA for a mutual fund or an interval fund.
Right. And this is a well-established position. FINRA actually put out a notice that said, effectively, because interval funds are distributed in a manner similar to mutual funds, they are exempt from FINRA filing and review, provided that they are governed by the same rules that apply to mutual funds. In this case, it's Rule 2341. So it is a established FINRA position that they will not review the offerings of the interval fund.
So, I do think that this is something that FINRA continues to look at, just like they look at all the products that are coming through, and they're looking at compensation, and whether they'll ever look at this in a different light, it's uncertain, but that's the current status. It's not required. It's a completely different area. So going on to the reporting requirement.
Right, so the reporting requirements, again, are exactly the same as the traditional closed-end funds that Cindy referred to, the annual reports, the semi-annual reports, and they will also likewise be subject to the same forms once they become effective. And similarly, unlike those of you listening who are familiar with the BDC structure, with the 8K requirements for any material events, interval funds, like the traditional closed-end funds, also do not have that requirement, but obviously you would sticker your prospectus in the event something material happened.
So are they RICs?
They are RICs. They can be taxed as RICs, assuming they meet all the same requirements of distribution and diversification.
So explain to us a little bit more detail about the shareholder liquidity and basically how that's established.
Sure. So like Cindy said, with traditional non-traded closed-end funds, there's really no requirement that any liquidity be offered to shareholders. It's largely a marketing-driven point where shareholders are going to demand some liquidity, and so non-traded closed-end funds like the non-traded BDCs that we represent established effectively a quarterly repurchase program through tender offers. Now that is, of course, completely discretionary, and so the board can shut that off pretty much whenever it wants. And this is where interval funds differ significantly from your traditional non-traded closed-end fund. An interval fund under Rule 23C3 must adopt a fundamental policy pursuant to which it pre-establishes the frequency at which it will offer to repurchase shares, and also mandates how much must be offered to be repurchased. So an interval fund has to declare at outset that it will either offer to repurchase shares every 3 months, every 6 months, or once a year. So effectively, you choose between quarterly, semi-annually, and annual repurchase offers. And every repurchase offer that you make has to be between a minimum of 5% of the outstanding shares and a maximum of 25% of the outstanding shares. And the reason there is obviously to make every repurchase request meaningful.
So let's just spend a minute on that. It's a fundamental policy. Mm-hmm. It's a fundamental policy means that you've got to have shareholder approval to change it.
To change it, correct.
So you are committing in your prospectus or your disclosure document that you are going to make this. So it's almost like a preferred return or something along those lines. It's because it's something you're definitely going to do, except, and we'll get into the exceptions. But
right, I mean, and that's, so when you establish your fundamental policy, you really need to give a lot of thought and make sure it is something that your investment strategy will make possible, because obviously you'll have to get shareholder approval if you ever want to change it, which can be quite onerous. And the frequency is pretty rigid. Even offering more liquidity is a problem. So the rules only allow you one additional discretionary repurchase offer in any 2-year period, which seems counterintuitive because we would think it'd be shareholder friendly to offer more liquidity. But once you set that interval, call it twice a year, and you want to do one more, you cannot rely on the same forms under Rule 23C3, but for once every 2 years to make that repurchase offer.
And so, are you using the same type of forms that you would for a closed-end fund, the Schedule TO and that type of thing, or is it more an easier filing?
It's an easier filing. It's called a Form N23C3. It's a lot of the similar information that you would see in a Schedule TO in terms of you describe the terms of the repurchase offer and other disclosures about the company, but the disclosure requirements are a little bit less onerous, just very high level. If a Form N23C3 comes out to maybe 15 or 20 pages worth of documentation that you file and distribute to shareholders, tender offer materials are probably looking maybe 40 pages worth of material. So similar disclosures, but slightly less onerous under the Form N23C3.
So let's just pause on this again, because obviously nobody wants to get into a fund they can't get out of. So now that we know that there's a fundamental requirement, or you're going to have to basically provide that liquidity during those periods of time, what are some of the other requirements under the rule?
As it relates to the...
You've got liquid assets.
Oh, sure. So thank you. The rule allows you to... It doesn't specify that interval funds have to have a particular type of investment strategy. So in theory, you can be an interval fund and invest in pretty much whatever you want. Having said that, you really need to be mindful of the liquidity of your portfolio, because when you make a repurchase request or repurchase offer, the rule requires that you have sufficient liquid assets to satisfy the full amount of that repurchase offer. So if you put out an offer for 5%, for a certain amount of time before the deadline ends, your portfolio must consist of enough cash or enough liquid securities that if everyone that you offered wanted to repurchase, you'd be able to have the money on hand to be able to make that repurchase request. So there's flexibility in your investment strategy, but there are also limitations under Rule 23C3 that mandate what kind of liquid assets you have to have on hand.
So again, the liquid assets definition, you have to be, the liquid assets refers to anything that can be sold or disposed of in the ordinary course of business, pretty wide open, and at approximately the price of what the company has valued the investment.
That's right.
So does that limit the interval funds portfolios or investments they can make?
It doesn't. I guess it does and it doesn't. You can, again, invest in anything that you want, but you want to make sure your portfolio manager is very mindful of what he or she is investing in. If you're a direct origination platform and all your assets are, typically your investments are in private loans, and you want to launch an interval fund, that's fine, but you just need to make sure that based on the type of frequency that you elect, your fundamental policy, that you invest in enough liquid assets to cover that. And really that desire for flexibility is where a structure that kind of has a hybrid between the interval fund and the traditional closed-end fund with their discretionary tenders might be of interest to folks in terms of the frequency that they choose as a fundamental policy for repurchases.
So if you want to do debt and you want to do basically some negotiated deals and some broadly syndicated, you could basically manage to that. But you would definitely need to have something that you could dispose of quickly, because you have to basically have 100% of the repurchase offer amount, right? And then you only have 7 days to basically make the repurchase.
Right.
Unlike, for example, just to compare it to a tender, which is 20 days, and there's obviously you can finance and do different things, but this is a very specific requirement to make sure, again, the money's there.
Right. And if you're still in your offering period, you can use cash inflows to manage the redemption process too. So there's different. I mean, it's going to be a fund-specific determination based on what's coming in and what they're holding.
And there is there's an SEC proposal out there about a liquidity policy. So there may be some more focus on that. It was a proposal or interpretive guidance.
Right. That only applies to mutual funds, but we'll see.
Yeah, I have a feeling that at some point they're going to apply to everyone. So when you're looking at this, what if somebody wanted to do if they wanted to invest in and this is a question that was asked, they wanted to invest in just private funds. through either a closed-end fund or an interval fund. Does that work?
Well, probably not, because because of the SEC's position that you can't have more than 15% of your assets in a private fund.
Yeah,
which is a separate issue other than from an interval fund. It's a sort of a long-standing position that the SEC has held.
Yeah, and to the extent the person that asked the question is wondering how there are existing funds that invest more than 15% in private funds, that was a rather lengthy and significant conversation we had with the SEC. I guess somehow some folks got through with that, but the official position now is that everyone is limited to 15%. Again, some funds may be grandfathered in that sense, but they've made it very clear that no new registered funds are going to get through if the investment strategy is to invest more than 15%, and you will be limited to the 15% of your assets in investments in private funds.
Right. And when we're talking about private funds, we're talking about C1 or C7. We're really not, even if a CLO would fall in that, the CLO is distinguished
yes.
For this purpose.
And real estate funds are fine as well.
Right. So what if you did have basically a portfolio? How would you of a private fund, meaning a real estate or a CLO? How would you value those? Someone's asking about how would you value them on a day-to-day basis?
I mean, I think people are coming up with solutions using third-party valuation firms as something that I think a lot of funds feel the need to turn to, because your board is going to want some support that valuation decisions were made, were given a lot of thought to. So, I mean, obviously the more complicated the asset, the more difficult valuation becomes, and probably the more expensive the whole valuation process will become overall.
So, and this is a question, since we're talking about this again, is do we think that the daily pricing is going to be something that effectively the market requires because of the fact that retirement accounts are getting into this class of securities?
I mean, I think as far as we know right now, all the interval funds that are out there do daily NAVs because they're doing daily sales.
Daily sales. Yeah.
And so if you want to be able to, and this really has to do with what channels these are being offered on, and how they're sold. They're often sold in the same way that mutual funds are sold, which means that the selling firms want to be able to put in orders every day and not have to have a different time frame pursuant which they're entering orders. And I would assume the same it'd be the same thing in the retirement-based market, right? That you want to put the money in every day. If you're going to be offered in a channel that typically has offered mutual funds, you're going to need to be selling every day.
So I guess by default, then they would have to strike an NAV every day because you're going to want to sell as often as you can, I would imagine.
So it looks like that's where we're going if we're not already there.
Yeah. And
we're there, and we don't know if other people are going to try different models, but right now I think everyone, or most everyone, is doing daily.
Yep.
And just I think we might have skipped over this point is that even though we keep talking about NAV as the pricing, technically you can't sell below NAV, but a closed-end fund or an interval fund potentially could sell stock above NAV. Usually we're using NAV as the pricing because that's the mechanism that's used here, but similar to other products, this could be you could actually be pricing it above that amount.
Well, non-traded closed-end funds are often sold, above NAV, but interval funds, mutual funds are required to sell at NAV, and interval funds usually comply with that and are selling at NAV.
And repurchase offers, I don't think we mentioned, have to be at NAV, so you can't, repurchase at a discount either.
So, Payam, we've been talking about the fundamental policy, what you have to do, what you're required to do. Can you maybe explain a little bit of different approach on some of this repurchase area?
Sure. So obviously there's a lot of benefits to being an interval fund from a regulatory standpoint, but there is, a fair amount of responsibility there with the mandatory repurchase offers. And generally speaking, offering more liquidity to shareholders is, from a marketing standpoint, desired. So most interval funds will elect the kind of maximum number of repurchases, which is the quarterly repurchases. To kind of solve for this problem of maintaining enough liquidity but also having a flexible investment strategy, we had clients approach us about a possibility of having a hybrid approach. So we looked into this and reached out to the SEC and effectively got them comfortable with the idea that you can combine a interval fund, a repurchase offer, with the tender offer process that Cindy described for traditional non-traded BDCs. And effectively, what you would do is that you would adopt your fundamental policy under the interval fund rules and take any interval that you want. But then on top of that, you would supplement on a discretionary basis with tender offers. So you would effectively be using just two different types of forms, whether it's a Form N23C3 the interval fund uses, but then you could supplement with tender offer materials, and you could take that really as far as you wanted to. In theory, well, not in theory, in fact, you can be an interval fund, get all the same benefits as all other interval funds, even if you take one mandatory repurchase a year, but then you can kind of say that you'll do your best or you intend to supplement that with 3 additional tender offers. And again, you can't do that as an interval fund only because you're limited to the one discretionary interval fund repurchase in any 2-year period. So that hybrid approach could be an interesting way to kind of have less of a required repurchase requirement, but then the ability to offer just as much liquidity to shareholders.
So really this type of approach, one gives us a little bit different view of the regulations and what's required, so it gives some flexibility, but it also allows managers maybe to look at a different composition of their investment portfolio because of the requirement on what they're committing to pay out.
Right, exactly. And from, again, you don't want to tell shareholders you want to limit their liquidity, but, if you have a great investment opportunity where that money from a shareholder best interest standpoint really would be better spent in this interesting investment opportunity, you could say, well, look, we're going to do one mandatory a year, but on a discretionary basis we'll do more, but if something better comes along than a repurchase offer, then you have that flexibility without kind of blowing up your interval fund status.
Right. And you'd have to do some work to get the market to accept these types of these differences in a program, right? Because we've talked about the market dictates a lot of these terms.
Exactly. That's the question. If you can get investors comfortable that, say, again, your one mandatory repurchase offer, in combination with kind of a best effort promise to do, 3 or 4 more a year, if that's palatable to investors.
So we've actually gotten a question on whether there is really an interval fund as an actual defined term, or is it really just a closed-end fund with a periodic liquidity?
The term interval fund is not used in the 40 Act, right? A fund that has elected to adopt a fundamental policy pursuant to Rule 23C3 has been referred to as interval fund, I guess for the reason that the fundamental policy selects the interval at which you repurchase your shares. But that is not a term in the 40 Act.
So I guess the question is, if we're going along with the new approach, it would still be an interval fund from a market standpoint because you have a fundamental policy, but you've got the discretionary piece as well.
Right, and more importantly, you're an interval fund from the standpoint of the SEC rules that apply to you that we talked about with, the registration statement being good indefinitely, the automatic effectiveness of your self-registration statement, and perhaps most significantly, the way FINRA views you without the substantive FINRA review.
So you took us right into our next area, which is what are the underwriting compensation requirements? We talked a little bit, but maybe you can take us through this a little more slowly.
Sure. Right, and so again, this is Rule 2341, and I think I probably said earlier that Rule 2341 specifically mentions interval funds. What it specifically mentions is any closed-end company that makes periodic repurchase offers pursuant to Rule 23C3. So there's no term interval fund. It always is going to refer you back to that rule. And as we mentioned earlier, because interval funds are not subject to substantive FINRA review, they're not governed by 5110, and they do not need a no objections offering to sell their shares. So we say they're governed by 2341, and so what that is it's the mutual fund sales charge rule, and it really limits the selling compensation. So the front-end loads for an interval fund, and again, this is the same rule that applies to mutual funds. The front-end loads are limited to a max of 8.5%, and that amount of 8.5% gets lowered depending upon other charges that the fund may have. So if the fund has 8.5%, it could not have a 12B1 fee, which is an asset-based distribution fee, and down to 6.25%, again, depending upon other charges. So I mentioned a 12B1 type fee, which is, again, a fee that a mutual fund typically charges, that interval funds have started to charge these types of fees. And again, not to jump ahead, but as we'll mention later, a lot of interval funds are operating as multi-class funds because many of them have received multi-class relief. And we're saying that they're governed by 2341, which is a mutual fund rule. By getting multi-class relief, a number of these funds have already also agreed to subject themselves to additional mutual fund rules. And so this concept of a distribution fee and a service fee, this comes entirely from the mutual fund space. And you do see interval funds charging these asset-based distribution fees and asset-based service fees.
And there's been a lot of movement in this area as far as how people are charging fees in different structures, somewhat because of the new FINRA rules, but also because of the DOL rules or anticipation of them. I don't know that there's been a kind of a market standard on some of that, but you're seeing a lot more trail or service fees of that nature.
I mean, again, I think the mutual fund space is really leading this just because it's so much bigger. But even in the mutual fund space, I think given the uncertainty with what's going to exactly happen with the DOL rule, there was a huge push for a T-share in the mutual fund space, and there's a similar structure in the interval fund space too, with a smaller load and a trail commission. And everyone registered for those shares, and not many people are offering them now because now it turns out that the selling firms don't want them. So I think a lot of this really is dictated by what the selling firms want to have on their platform.
Another question we got, Cindy, is just, does FINRA need to review broker-dealer distributor information if it's just going to the broker-dealer and not going out to the ultimate investor?
You mean marketing materials?
Yes, marketing materials.
I mean, no, if you look at the FINRA rule, that does technically not need to be filed with FINRA, although in some state cases it is often filed. But
you want to be careful about something like that. It can always leak out.
But FINRA also, the process for filing it, you don't always need to file it necessarily before it's used. There's a delayed review process too. So it's the rules are complicated. Right.
I think most interval funds do have their marketing pieces going out to investors. They have to have those reviews.
Yes,
right?
absolutely. Yes.
Anything that's going to, the guiding point should be anything that's going to hit the ultimate investor, you definitely need review. If there's something that you're going to be keeping in-house with one of the independent broker-dealer firms, something along those lines, you may not need to, and it goes to your risk analysis there. Right. So let's go on to the offering process, and Payam, maybe you can talk to us a little bit about that. Some of this reiterates some of the points we've been talking through.
Yeah, we talked about the continuous offering of shares, the requirement to strike NAV on a daily basis, the fact that you have a registration statement that does not have a 3-year life, and the more efficient manner in which you can update by post-effective amendment your registration statement. But really the benefit of interval funds is that stems from the view, which has got them the FINRA exemption, is that they are similar to mutual funds, again, even though they are technically closed-end funds. And it's that view that has allowed greater flexibility on the part of distribution platforms to allow interval funds onto their selling platform. And the benefit of that is that you have a much more efficient distribution method. These large platforms that sell mutual funds, they use a system referred to in the industry as point and click, which is significantly easier than that, say, that non-traded BDCs, the process they have to sell shares. Those of you who have non-traded BDCs, you know that in order for any investor to buy a share of a non-traded BDC, they have to complete a long paper subscription agreement. In the case of an interval fund on a distribution platform of a big broker, it's just a couple clicks on your computer and you can sign up to buy shares of an interval fund. And for reasons that I'm not entirely clear as to why it is that with an interval fund, these platforms have demonstrated a greater willingness to put them on their platforms as opposed to a traditional traded closed-end fund, I don't know, but I don't think there's anything preventing a traded traditional closed-end fund from using the point-and-click platform. But again, for whatever reason, interval fund seems to be looked upon more favorably than your traditional closed-end fund.
So, what are some of the other, we talked about the distribution method. Anything else, any other considerations you've got when you're looking at the interval fund structure?
So the considerations are really what we've discussed in terms of the various requirements, specifically as it relates to the frequency of NAV determination. You're going to have a fairly heavy administrative role to play as a manager of an interval fund. So that's just something to keep track of. You know, you've got the daily valuation. If you're doing daily NAV, you need to make sure that your investment strategy is consistent with your ability to offer repurchase requests. So there is a fair bit of monitoring to do from a kind of a back office standpoint. So that is certainly something to be aware of before launching an interval fund.
Anything else you want to mention about the liquidity that we haven't already gone through, or how you want to manage that, the composition? I think we've talked a little bit about it.
Yeah, I mean, again, it's just really up to the portfolio manager to make sure that whatever strategy that he or she wants to employ will allow for the necessary liquidity, and to kind of balance the desire to give shareholders liquidity, perhaps with that hybrid process that we described, to not limit what you're investing in, but also be able to provide meaningful liquidity to your shareholders. And of course, marketing consideration, you know, what you can market, what people will buy will largely drive that.
And then just maybe quickly, because we're running up against time, is there the ability to have multi-class relief for interval funds?
Yes. So, you know, for reasons that I certainly don't understand, interval funds and I guess registered closed-end funds routinely and rather easily get multi-class relief. And that's obviously a sore spot for our friends with non-traded BDCs. We're still waiting on that. But an interval fund on a very routine basis can get multi-class relief. And really with where that comes in handy is with the the fee structures that Cindy described. You as an interval fund, once you get multi-class relief, you can offer as many different share classes as you want, and you can have any combination of the fee structures that Cindy alluded to. So you can have a share class that only charges a front-end load, and you can charge up to 8.5%. You can have a share class that has an upfront load, but then also a distribution fee on a trail basis, and that reduces your total 8.5% down to, I think, 7.5%. But you can play around with any combination of that fee structure with a front end, a distribution fee, and a service fee, and offer any number of those class share combinations with multi-class relief, which again is really just a few months away upon filing.
Right. And just to be clear, most of these exemptive orders, they apply to interval funds, and they also specifically will apply to any closed-end funds that make periodic repurchase offers pursuant to the tender offer process. So this is one instance where non-traded closed-end funds and interval funds are actually treated similarly, and non-traded BDCs are excluded.
So we're going to bring our discussion to a close, and we got a lot of questions today, so if we didn't address your question and you'd like us to, you certainly can email any one of us and we can talk you through that. One of the questions that came up that I wanted to talk about was just why would you choose an interval fund over, for example, a mutual fund or potentially an ETF?
To offer?
Yeah.
Well, I mean, the big issue is the management of a mutual fund requires you to offer daily redemptions, right? So you have to be able to manage. First of all, they're limited to 15% liquidity. They're also subject to the new liquidity risk management rule that the SEC adopted, which will be an additional sort of onerous compliance process. But I think they're subject to 15% illiquid only, so you're really limited in what illiquid assets that you can invest in. You also need to be able to meet daily redemption requests that are in no way limited by you, right? You could have a daily redemption request for half of your portfolio, and you have to be able to meet that. The non-traded closed-end fund and an interval fund allows the manager to much better manage the redemption, right? That they're only offering liquidity on a limited basis, so they don't have to be prepared. They don't have to be prepared to redeem their shares daily.
So, and this, I asked that question because this really does lead to our last point in our conclusion, which is, when you're looking at different types of fund structures, you really do need to compare and contrast and look at, what is your investment strategy, what kind of shareholder liquidity do you want to offer, what kind of distribution model are you looking at or do you have, and then, of course, the operational administrative requirements and the costs around those. And that's what we would suggest is that effectively you need to look at all the different variety of funds and see which one would be most appropriate for you as a manager, and you may need all various products, meaning interval fund, a BDC, an ETF. You could have a full panoply, and we are obviously seeing a lot of people taking advantage of various products for different reasons. So we do think that we'll be coming back to you with some other Lunch and Learn sessions. If you would like a copy of the slide presentation that we've gone through today, email one of the presenters, myself, Cindy, or Payam. And I want to thank everybody for joining us, and we'll talk to you soon. Thank you, guys.
Thank you.
Thank you.
Thank you. This concludes today's conference. You may disconnect your lines at this time. Thank you for your participation.